Here's the summary of arguments on issues as contained in Bat Shetima's final address. Issue 2. Whether the second and third respondents, Bat Shetima, that is Bola Ahmed Tinubu and Shetima, were not eminently qualified to contest presidential election of 25th February 2023. So this second summary from the petitioners that Bola Ahmed Tinubu and Shetima are not qualified to be in the presidential and to contest for the presidential election of 25th February 2023. But here is their final address. They are now disclaiming it and they are saying that Bola Ahmed Tinubu is qualified. So let's see what they said in their own final address. They opened the argument with the US proceedings and argued that the judgment had not been registered in Nigeria in line with the clear provision of Section 3 of the Reciprocal Enforcement of Foreign Judgments Ordinance and Foreign Judgment Reciprocal Enforcement Act. For judgment, they further argued that it is only the process of registration that will make it a judgment that can be enforced, putting use of relied upon. They supported this with the cases of Grosvenor Casinos Limited, Halowa Ogidi State, Sona Paterindri MS, Norwind. They entrenched themselves in their position even more and argued that none of the witnesses, BW1 and BW12, presented in respect of the issue could present a certificate of conviction or photographs of the fingerprint of second respondent, Bola Ahmed Tinubu, to show that he is the one that was convicted in the said judgment, and shielded their argument with Section 248 and 249 of the Evidence Act for the proof of previous conviction of a person outside the Nigerian jurisdiction. So they are claiming that nobody could present the fingerprint to prove that it was Bola Ahmed Tinubu that forfeited whatever he forfeited. They forfeited their position that in any event, that is to say, if the court chooses to uphold the judgment CTC as admissible evidence, BW1 confirmed the proceedings in Exhibit PA5, the judgment, that is the judgment. They were civil proceedings without charges, and that since the proceedings were criminal in nature, they could not have amounted to a conviction under Section 137 of the Constitution. They then assumed without coinciding that even if it is a conviction, the conditions precedent for the proof of the criminal allegations are far from being met by the petitioners, that is the Labour Party and P2B. This made me wonder if they wanted to carry out another trial, as I cannot understand what criminal allegation they are proving in a matter from another jurisdiction where a judgment already exists. They then proceeded to try to damage LP's witness, BW1, by the number of times he had visited the US, which was once, against their own witness, who is a US attorney and counselor, who is more knowledgeable about US law. They backed up their position with Exhibit RA9, a letter from the US authorities to the Nigerian authorities attesting to the fact that upon a thorough combing of the FBI National Crime Information Center, NCIC, the second respondent, Bola Ahmed Tinubu, maintains a clean criminal record in the US. The supposed letter, according to them, goes on to state that for the avoidance of doubt, the NCIC is a centralized information center that maintains a record of every criminal arrest and conviction within the United States and its territories. The second leg of the argument on the same matter stood on Nigerian law as they tried to draw a parallel between Tinubu's circumstances in the US and non-conviction based forfeiture, that is NCBF, the non-conviction based forfeiture, a forfeiture not associated with criminal conviction or sentencing. It appears to me here that the respondents have created their own issues as the operative word in Section 137, subsection D of the Constitution that the petitioners alleged was breached is that he was fined for an offence involving dishonesty or fraud. For me, this is like an unnecessary wild goose chase by Bola Ahmed Tinubu Shetima as they are creating issues that don't exist and attacking themselves. So now what Bola Ahmed Tinubu's council is trying to do, the issue being discussed is whether the respondents Bola Ahmed Tinubu were qualified to run for presidential election. The argument began with the registration of a foreign judgment in Nigeria stating that it must be registered to be enforceable. That means anything that the Labour Party are claiming is not yet registered in Nigeria, so it cannot be enforced. That is what Bola Ahmed and Shetima Council are claiming in their final address. They also questioned the evidence presented, such as a certificate of conviction or fingerprint to prove the respondent involvement. They argued that even if the judgment was considered, it should not be seen as a conviction under the Nigerian constitution. Bola Ahmed Tinubu, they are really joking with Nigerians. Now we continue. They further attempted to obfuscate by submitting that NCBF is codified into Nigerian law and quoted section 13 subsection 1 subsection D and 24 of the Economic and Financial Crimes Commission Establishment Act 2004 EFCC Act, section 48 of the Corruption Practices and Other Related Offences Act 2000, section 12 of the Advance Fee Fraud and Other Fraud Related Offences Act 2006 to back it, and further submitted that the action was brought in rem against the property and the custom in the United States is to name the property that is subject to forfeiture. In the caption of the case, they gave examples of cases like United States real property located at 475 Martin Lanois, United States, 1 Red 2000 Hummer H2 to back up the argument, and concluded that a forfeiture action may be commenced before a related criminal case is filed, while one is pending, after one is concluded, or if there is no related criminal case at all, and in the case of the facilitating property, the owner of the property does not have to be the wrongdoer. You see that what they are trying to do here. So what they are trying to do here is that they are claiming that Bola Ahmed Tinubu forfeiture was done by his account, not himself. So that means if there's a case of the owner property the property of the owner is used for crime, maybe his car is used for crime, that doesn't mean that it's the owner of the car that did the crime, it is the car that was used for crime. He then submitted that even in the scenario that there was a conviction, that section 137 subsection I subsection E will stop the court, as the conviction would have expired if it has been over 10 years. Take note that the petitioners brought this under 137 subsection 1 and D, not E, and respondents have started another wild goose chase. If I analyze the argument on this with Exhibit RA13 and RA16, we show that the Tinubu has always enjoyed rights of entry and exit from the US, a right which anyone who is burdened by a criminal forfeiture cannot enjoy, as if ex-convicts cannot be issued visas under the US visa waiver program. We need to understand some certain things before we begin to clap for some liars like Olenipekun. On the double nomination of third respondent Shetima, they argued that via a letter dated 6th of July 2022, he informed the second respondent Tinubu and also informed APC of his withdrawal. They want that date to be the recognized date of his withdrawal, whereas the INEC letter was submitted at a later date. They further elucidated on Exhibit RA27 judgment of the Supreme Court on the double nomination issues and submitted that Shetima's submission of his letter to Tinubu and APC was the withdrawal itself, and the letter of the APC to INEC was a convenience of the withdrawal, and urged the court to rule on this issue in their favor. Hey, we are moving swiftly, and I can tell you that APC has no case. They have no case at all. It is not necessary for foreign judgments that have been fulfilled or served to be registered in Nigeria. Registrable judgments are those that require enforcement. Tinubu already forfeited $460,000 as a fine. He already fulfilled his part in the eyes of the law, so there would be further enforcement. So no need for registration according to the Foreign Judgment Reciprocal Enforcement Act of 1960. It is the stigma that Section 137 1D is talking about, but not about serving out or fulfilling the punishment. You see, these people don't understand that the obedient are wise. They are very learned. We're not like PDP. We understand what is going on. And for the fact, there is going to be a proven fact. Thank you for supporting the Future News. Peace.